My name is Art Hinshaw. I'm a graduate of Lee Elementary, Jeff Junior High School, this law school twice. This is where my home is, my heart is, and I'm very, very happy to be here. I was a member of the Journal of Dispute Resolution. Michaela was kind enough to drive me by my childhood home yesterday from the airport. It's just been fantastic to see everyone and to listen to what we just heard, the first Riskin lecture in dispute resolution. Wow. Duo, Charlie Brill and Mitzi McCall. Does anybody know who they are? And what they're famous for? Well, yes, probably so. But it was 80 years ago, right? No, 60 years ago this year, that these two famous comedians at the time followed up the Beatles on the Ed Sullivan Show when they first came to America. And so I kind of feel like that's who we are. But with that said, we do have a charge. I'm here with 4 amazing dispute resolution scholars. And our charge is to basically look at the future. What does the future have to hold? I mean, some people have said, dispute resolution, everything's been done. There's no future in it, from an academic standpoint. From a practice standpoint, sure, there's a lot of it going on. And I have 4 amazing people with me to rebut that notion. So on my far right, Donna Shestowsky from UC Davis. My close right, your left, Cynthia Alcon, Texas A&M. My left, the famous Mizzou Law School current professor, Rachel Westschler. And then on the far left, Jennifer Rodham, former Mizzou Law professor. So the first thing before I hand it off, we're going to talk about what the future holds and what it looks like. But I want to thank those of you who are 3Ls who are still here. Are there any? Because I want to talk about this quickly that I'm part of and Andrea Schneider is a part of. And thank you, Paul Leitehoff, for helping us with this. One of the things that we are doing is we are in the 3rd year of data collection on a 3-year longitudinal study of law student negotiation behaviors. And we started with this group, with your group. I hope you've taken me, filled out the data. But we're doing this to see how students change over time on a variety of different metrics. And so this is the 3rd year. Look in your emails in April. Paul, the information is going to be coming to you in not too far distant. So we're looking, you all are a part of what the future of the academic world looks like, and it's going to be thinking about dispute resolution and negotiation and how students develop over time. And second thing, and then I will be quiet. Professor Lee was very smart to have me be the moderator of this program. Why is that? Because I was the person who said, when asked to teach negotiation online, you can never teach dispute resolution in an online environment. Never. It will never, ever happen. Hello, COVID. Then, about 10 years after that, people were like, wouldn't it be good to get dispute resolution on the bar? I said, that will never, never happen, ever. Why waste your time on this? You're just beating a wall. And so clearly my predictive powers are very poor. So therefore I'm the moderator. So Donna, you have some things about online dispute resolution that you want to talk with us about. Do you have a clicker and anything you need? Yeah. All right, go ahead, Donna.
Thank you very much, Art. Hello, everyone. I'd like to thank everyone who was involved in putting together this terrific conference. Thank you so much. It's been a wonderful day. I don't see Professor Lee here, but thank you, thank you, thank you. So as Art mentioned, and this was part of the teaser for this panel, this big question of have all the important questions been answered? And my answer to that question is for sure not. And one reason for this is that we have a relatively new innovation in our field. And that is online dispute resolution, which is also called ODR. And that was introduced in the American court system circa 2014. And I'm oversimplifying things a little bit by defining ODR in this way, but as it exists in our court system, because that's going to be the focus of my presentation, ODR is essentially ADR offered online. So for example, mediation that takes place not in person, as you've probably been learning about it in law school, but through a device like a laptop or a cell phone. So prior to the pandemic, people already appreciated the convenience associated with doing things online, right? Finding their spouse online, shopping online, moving money online. By comparison, though, the court system had been and still is far less accessible. It continues to be constrained by inconvenient business hours. It involves disputants incurring direct costs, such as for transportation, sometimes indirect costs when they go to the courthouse to handle their matters, in the way of, missed pay from work if they have to take time off of work, babysitting costs, elder care, that sort of thing. And that's a really big problem. And because of this, courts are at risk, I argue, of having a perceived legitimacy problem vis-a-vis their constituents, their consumers, so to speak. In fact, ironically, courts risk encouraging people to forgo pursuing their legal rights altogether for access to justice reasons when it's so inconvenient, or to motivate them to use private channels for resolving their disputes, thereby rendering the public form of the courts a lot less relevant and a lot less sustainable over the long run. But maybe not, if they offer ODR that litigants find appealing, right? That's the potential and that's the theory. But we need data to know how litigants view ODR and how it affects the administration of civil justice. And neutral studies to try to answer these questions really have only just begun. And I know this because I happen to have been involved in, it was only 5 years ago that I was involved in some of the very first evaluations of court ODR programs in the country. When in 2019, the Pew Charitable Trust awarded funding to Jennifer Schack, who's Director of Research at RSI, and me at UC Davis, so that we could conduct the first neutral court evaluations in the US. And those projects just wrapped up a couple of years ago. So we're really talking a very short time ago that we had some data from neutral sources making these kinds of evaluations. And part of our charge from Pew was to answer the following questions. Does ODR save courts money? Does it save courts time? And how do the litigants feel about it? This list might look familiar because these are the same questions that were amongst the very first questions that were asked when ADR was first introduced in the courts. Given where we are with ADR today, it's hard sometimes to remember that the introduction of ADR programs into the court system was considered an experiment. It was an experiment, and that experiment was set up to figure out whether it could save courts time and money. And when some initial programs failed to realize those types of efficiencies, courts started to promote ADR, especially mediation, on the presumption that litigants preferred it to judicial communication. Since then, litigants' preferences for procedures have become a question of empirical interest in their own right. And many procedures, certainly mediation, but also arbitration, trials, hearings, and so forth, have been scrutinized empirically. And there have been by my library's count, over 1,000 relevant studies. And so that might lead you to wonder, when courts want to offer these procedures, but then just put them online, don't we already know everything we want to know about them? And my view is that itself is an open empirical question. But I can honestly hypothesize quite a few reasons why research on how litigants experience ADR procedures in person might not translate to how they experience them online. And here are some reasons, some informed by the research that I did with Jennifer. So what is the reason, what is the difference in terms of how litigants communicate? So many people don't know this, and this came as a surprise to us when we did these evaluations, is that just about every court ODR program in the country relies on asynchronous text-based communications. Okay? That's potentially a dramatic departure in terms of communication modality compared to what's been studied in prior research on in-person ADR. Not only that, but our evaluation work suggested that up to 3/4 of parties who are using these text-based programs are using exclusively their cell phones to use ODR. Okay? So that means to understand court ODR, we need to research on how parties resolve conflict by using text on their little itty bitty cell phones. Another difference between ODR and the traditional forms of ADR that have been studied so far is who's excluded from participation. In-person ADR programs that have already been studied tend to fall into one of three categories by my count. Procedures that involve unrepresented parties who attend procedures on their own. Procedures where parties attend alongside their lawyers if they have one. And procedures that involve lawyers attending on their own. Okay. In contrast, though, because court ODR procedures are asynchronous, typically only one person is allowed to use the portal and register on the online portal. Okay. And our evaluation research has suggested that this often results in the affirmative exclusion of attorneys, even when parties are represented. And the implication of this program design element has not yet been fully understood. A third difference between ODR and traditional ADR programs relates to procedure type. In-person court ADR programs typically involve some kind of third-party facilitation in the form of early initial evaluation, mediation, non-binding arbitration, that sort of thing. But in contrast, court ODR programs feature generally negotiation, either as a standalone process or as something that people use, and then if that doesn't work out, if they reach an impasse, then they go on to mediation. Okay. So in a very interesting way then, based on what we've seen so far in terms of court programs, they basically have created a situation where courts are mandating a very specific text-based form for bilateral negotiation between only the parties, even when they are represented. Okay, and these wrinkles really create this challenge in terms of us understanding how well and whether at all what we know about in-person ADR translates to how people experience ODR, at least from the litigant's perspective. And here is one more reason to be skeptical in terms of how what we know about in-person might translate to online dispute resolution. And that's that we found in very recent research that litigants don't appear to make decisions about using text-based ODR opportunities like they do in-person opportunities. So consider this the result of a multi-state study that I conducted a few years ago, way before ODR was introduced in the courts. And in this study, I asked state court litigants at the end of their cases, after they've been resolved, what factors determined the procedures that ended up resolving their case? In other words, when they were choosing amongst procedures, what factors did they rely on in making a decision about which way to go? And the most commonly cited factor by far was attorney advice. Over 20% of litigants indicated that their lawyer influenced the selection of the procedure that ultimately resolved their case. So that's the left two most columns of data there on the slide. And 27% said that lawyers motivated their use of any earlier procedures that they tried. So if they tried something like negotiation, that didn't work out. What else they tried? So these results resonated with findings from very prolific scholars like Art Hinshaw, Bobby McAdoo, Roselle Whistler, who documented the influence that attorneys have in raising the possibility of using ADR with their clients and getting them to even consider that as an option. But here we found that even ex post, after the litigants themselves are surveyed in terms of how they conceptualize what made them use a particular procedure over another, they're saying the attorneys basically persuaded them to do it. So my psychologist friends and I, Andrea Wolfs and Debbie Goldfarb, we recently conducted a laboratory experiment to examine the issue of attorney influence from a very different perspective. And our question was, basically, when disputants have a choice between in-person ADR, text-based ADR, and video ADR, how do attorney suggestions influence that choice? And for this, just to keep it simple, since it was an initial study, we only looked at how they viewed mediation options. So what we did was we recruited a diverse national sample of about 250 adults. They read short descriptions of three modalities: in-person mediation, video mediation, and text-based mediation. And then they read a case vignette, but they were asked to assume that they were a disputant in that particular case. And they rated the attractiveness of each of the modalities for that specific case from that particular perspective, okay, from extremely unattractive to extremely attractive. And those were their baseline ratings. And then they read a message that came from their hypothetical attorney. And included in that message was the attorney's suggestion as to what they should actually use for that particular case in terms of modality. And the recommended modality was completely randomized. So it either completely aligned with what their baseline rating suggested was their preference. So for example, if someone said, I prefer to use in-person ADR, they had a 1/3 chance of getting an attorney's message saying, yes, you should use in-person ADR. They had a 1/3 chance of saying, no, the attorney was saying, no, you should use a video ADR. And they had a 1/3 chance of saying you should use text-based mediation for this particular case. So it was completely randomized. And after reading that message from their lawyer, they then indicated what they actually wanted to use for their particular case. They were going to make that choice. And we found that attorneys' recommendations actually mattered, but not for text-based ADR. Okay, so when attorneys favored in-person mediation, if you can see there on the left-hand side of the screen, that's what the participants were most interested in. When the attorneys favored video mediation, that's what the participants were most interested in. But when their purported attorney basically advised them to use text-based mediation, that advice did not affect their preferences. Those lines there on the right side of the screen were completely the same in terms of statistical significance. So one big takeaway here seems to be that even though attorney advice tends to influence clients' procedural decisions, which we found in earlier studies on just in-person ADR, there might be something so unappealing about text-based mediation that not even attorneys counsel to use that ends up altering their decision-making with respect to what to use, okay? And that is what courts are using right now. They're using text-based approaches to conflict resolution. So to close, I asked the same question that I asked at the beginning of my presentation. Is ODR the future of ADR? It may very well be, but even if it is, we shouldn't assume that what we know about litigants' experiences based on our in-person research paradigm so far will necessarily translate to how they're going to perceive these ODR options. So more research certainly needs to be done. And just one little word back into the history of this, when we were trying to understand court ADR programs in the early 2000s, okay, studies that were done back in the 1980s and 90s were challenged as not being very useful in helping us understand the early 2000s because so much had changed within that period of time. People's experiences and understanding of what ADR meant, how attorneys advocated for their clients in these procedures had changed, even how the neutrals themselves constructed the experience for litigants, that had also changed. And things changed a lot more slowly back then than they do now. So unlike ADR programs, literally, and we saw this in our evaluations, courts could literally change their ODR programs with a click of a button. With a click of a button. And bam, a new program had emerged. So really studying these things kind of feels like studying a moving target. And with AI, good luck to us predicting the future.
Seriously.
Seriously.
Good luck on this. Really interesting research, in part because many of the heavily populated counties, cities across the United States are going to all online hearings. You have to specifically request to be in person for you not to be scheduled on a video hearing. Get ready, it's coming. It's not with you already. Yeah, exactly. All right, so we're going this way if you haven't figured it out. So next, Cynthia is going to be talking about her area of expertise, which is we call it dispute resolution in the area of criminal law and things along those lines. You might think of it as plea bargaining, you might think of it as systems, you might think of it as alternative courts. So as we got it, we're working there.
We're getting through.
That's how much I can. Yeah.
Okay.
Okay, there you go. Okay.
Okay, there we are. Excellent. Okay, now we have the slides set. Cynthia, take it away.
Okay, so thank you. So I'm gonna talk just very briefly about looking at the criminal legal system, which has not gotten a lot of discussion so far today. So my task here today is to try and look forward. And I think the first thing to recognize is when we're talking about our criminal legal system, by definition, we're talking about a wicked problem. It's complex. There's no single criminal legal system. Some would say there's several thousand, one for each county. I think it really breaks down courthouse by courthouse. So I think it's even more complex when we're thinking about how it works. But today I'm going to try very hard to not focus on the challenges and the problems, but to look forward and to think about where, when, and how dispute resolution can contribute to improvements in our criminal legal system or systems. And my goal today is to try and look forward with optimism, which is not generally how we talk about our criminal legal system. So I'm going to try very hard to bring that view into what we're talking about with our criminal legal system. So first of all, I think it's important just to recognize for those who aren't criminal practitioners or never worked in the criminal legal system, when we're talking about ADR, what are we talking about? So obviously, of course, plea bargaining, and I'll talk about that a little bit more in a minute. And I really consider plea bargaining to be the entree point for all other forms of dispute resolution in our criminal legal system. So it's because of plea bargaining that we have problem-solving courts. For the most part, we have no firm rules. We have no laws around problem-solving courts, with a few exceptions. That Texas mandates, for example, that drug courts exist in every county with over 200,000 people, but we don't have firm rules about how they should be running. Like, this is all a product of informal negotiation and agreement, the problem-solving courts. And these include drug courts and mental health courts. The first of the problem-solving courts is often considered to be juvenile courts. There are more rules around those, but arguably as the rules are grown up, they become less problem-solving. So, but I'll put all that aside. And then the final form of ADR would be broadly restorative justice. I'm not going to talk about that at all because we've got Rachel to talk about that. So I will skip over that for the purposes of this discussion right now. So plea bargaining, right, is the big one. Spent a lot of time thinking about it, right? You've done it a bunch. It's a form of negotiation. It is nothing new. Our criminal legal system has had it since at least colonial times, if not before. And it is currently the dominant way in which criminal convictions happen in this country. Depending on the jurisdiction, 92 to 97% of criminal convictions are due to plea bargaining. And depending on the type of case, it could be even higher. 100% of cases. I've seen data coming out of Tarrant County, where I live, in Fort Worth, 10 years worth of data with drug cases, 100% of the convictions were due to plea bargaining, right? So if we don't have uniform rates across offense types, but certainly it is the dominant way in which criminal convictions come to be in our system. And I've written a lot, and other people have, about criticisms over, I'm going to restrain myself, not go into those. But the bottom line is there's very few rules and very few constraints around how plea bargaining works. It's really a product of what do people agree to? What do the prosecutor, defense, and the judge agree to? And that's what makes it work. And for the purposes today, I think what's important to recognize is this means that we have embedded into our criminal legal system flexibility. Right? We are not rule bound in how we think about what we're doing with criminal cases. It's not to say rules don't matter. They do. Law matters. Sentencing laws matter. All of that matters. But we have embedded into the system an ability and a process where that allows for creative thinking and allows for innovation. And I think it's important to remember that because it has led to some of the things we've already seen. And I think it can lead to a lot more. Right? So when we're trying to think optimistically, I think it's important to remember that this is the culture of our criminal legal system, which can be very helpful in terms of thinking about how dispute resolution can help. So one of the things I wanted to think about and talk about just briefly is what are some of the things that are new around plea bargaining? We've had it since colonial times, right? It's an embedded part of our system. But what's new about it when we're thinking about it now? And I think one of the things that's new is there's, compared to say 30 years ago, not necessarily 60 years ago, but rehabilitation is discussed a lot more now than it was in the 1990s when I was practicing in Los Angeles County. The 1990s is often talked about as the incarceration decade. Mass incarceration shot through the roof in the 1990s. And I can tell you it was very hard to have any conversation about rehabilitation in that era. We're in a different era. It doesn't mean in every case we're there. It doesn't mean with every prosecutor we're there. It doesn't mean in every courthouse we're there. But we have a lot more discussions around rehabilitation. We've got things like progressive prosecutors that often base a lot of their work on thinking about how to put more rehabilitation into how they're looking at managing and handling criminal cases. There's also, I think, a building awareness. I wouldn't say it's where I want it to be, but I think there's a building awareness of the importance of training for negotiation. So, and it's sometimes in some places, And it's still not, given a choice, if there's resources, public defender's offices will choose to do trial training over negotiation training. I've many times been asked to do negotiation training, they're like, wait a minute, we don't have the budget for you, we've got to do our trial training, right? So I see it in practice, this focus on trial training. But I think one of the things that I see happening, and I think when we're talking about the 40th anniversary and what Len and others here have gotten started, is I've seen often when I'm getting contacted by people about doing training, there are places where there is dispute resolution training happening. So Professor Schneider and I last year went to Connecticut, Quinnipiac. I don't think it's an accident that the state public defenders asked us to do a training on negotiation. A lot of their folks went to Quinnipiac. They got a lot of training. They understand the importance of negotiation. And I think we see this in pockets, right? What we're doing in law schools around the country, it's not as much as any of us would like. It's not as overwhelming, but it matters. And it's making an impact slowly, piece by piece. We're seeing more of a recognition of the importance of doing this kind of training as part of key lawyering skills. The other thing that I think is new, when we're looking at what has been happening through plea bargaining, is the innovations through things like problem-solving courts. So problem-solving courts, in my view, are entirely a product of plea bargaining and plea negotiation. First direct court started in 1989 in Dade County, Florida, and it started because judges there thought, or a judge there thought, we can do better, and got the prosecutor and the defense attorneys to agree. And they did better. There was no law passed in the state of Florida to allow for drug courts. They started it, and they've taken off across the country. There are, beyond problem solving, beyond drug courts, there's mental health courts, there's veterans courts. I just, saw the veterans clinic that is here at Mizzou, right? So we've seen an increasing number of these. Every jurisdiction has at least a drug court, or just about every jurisdiction, from rural to urban. The challenge, of course, is only a very small percentage of defendants are getting into these courts, right? So, but they're there, and it's about a changing thinking. How do we get to the root causes of criminal behavior? What might help to prevent repeats, and what might help to rehabilitate people so that they aren't continuing to just pick up case after case. I think another interesting development, and I wanted to highlight, so we've got, I may mispronounce your name, I'm sorry, Judge Fahrenstock, right, from Division 9 in Jackson County, Missouri, and we've had some very interesting conversations. She started a very interesting mediation of criminal cases program in her court, and these are mediations of serious criminal cases where defense and prosecution and defendants are coming together to talk about settling cases, right? So it's a plea bargain mediation. There are mediation programs. I know Sarah Pellis talked about it at Ohio State. There's some through where there are less serious criminal cases that are getting mediated, where you're bringing parties together, or less serious cases with the victim and someone in there. These aren't necessarily restorative justice, and so we see these happening in a variety of courts around the country, different structures, different ways of doing it. But I think what's important, and what really struck me when I've spoken about what's going on in Jackson County, is what influenced the development of that is what's going on in our civil system, right? So the judge has had experience with civil cases, mediation in the civil context, and when she took over a criminal docket, thought, why can't we do that here? Right? And so I think it's one of the things that's important to think about is that we have influences happening from a variety of places, right, coming into our criminal legal system. And I think those, done right, should only increase, right? We should see more over time and see more ways that we can innovate to do better. One way to try and bring better dispute system design into our criminal legal system, I think there's much room for this to help in terms of thinking about what we're doing and trying to bring key stakeholders into the conversations. One of the challenges with state problem-solving courts is they're often judge-led, and they may get buy-in from prosecutors and defense lawyers, but they aren't necessarily a product of a bigger conversation about about what we're doing, how we're doing it, and what kind of programs that we might design to do better within the criminal legal system. And we've got serious issues about not being well prepared for emergencies and crisis situations that dispute system design could help with a lot. We saw this during COVID. Our criminal courts went into shutdown, as did everything else in our society and our world. But in the criminal courts, it was all over the place, how it was getting dealt with. Some had very collaborative cultures, so there were collaborative conversations, and some it was the judge decided what to do, and then you had defense lawyers and prosecutors trying to figure out how to manage something that they didn't think was the best approach, right? And so thinking about how to do better in terms of using what we know is helpful in dispute system design, I think is the next level that we could bring things to improve what's going on in our criminal legal system. And then, of course, there's technology. Right, so Art started out that in every courthouse around the country, the default is online, not in criminal. Right, criminal will be the last, right, where we're gonna see that. And there's concerns, there's reasons, right, but there's also a lot of this is how we do things. We need to bring people in person, I think there's, and which means we aren't necessarily thinking about all the ways we could use technology to improve and I think in part, it's important to think about how can we not only improve for efficiency, which is where the criminal courts like to go first, but how can we improve for justice, right? Are there ways that we can avoid doing what Malcolm Feely talked about, over 30 years ago, where the process is the punishment in our criminal legal system, right? How can we do better? And we can make the process more friendly and more open, and so defendants don't have to come in for 15 court appearances before trial, which is what wears them down and gets them to take deals that maybe they shouldn't take. Right, so thinking about how we can use technology for better access to justice, I think is another forward-thinking thing that we can do. We know that the criminal legal system is not stagnant. There are no shortage of folks, both inside and outside of the system, who want to see it work better. We see this happening in a variety of ways, which means that changes are happening. And that always provides opportunities for improvement. And I think that's something where we're looking forward. We can look forward with some optimism on that front.
What I was saying is that presumably there is public data available on plea bargaining outcomes because people have to go before the judge and say, yes, we're going to do this. So are there opportunities for research in that area?
So you would think there would be better data than in fact there is. Right? Our criminal legal system has a problem with collecting data. Andrew Schneider and I wrote Bargaining in the Dark a number of years ago to complain about that. But one interesting thing, and it's a project I've just started working on, New York State has started collecting a lot of data in connection with their bail reform law, which passed in 2019. Starting in 2020, they have publicly accessible data that includes a whole lot of stuff that's really interesting for understanding how plea bargaining works. And so I'm starting with a partner to look at that. So hopefully, soon we'll have some better information.
All right, journal editors, listen up. Okay, good stuff down the line. All right, so we're going to go to Professor Wexler, please. Restorative justice, tell us.
Yes, thank you. Now I'm handling the second part of your criminal law and dispute resolution program today. Okay, great. So I am excited to talk to you about restorative justice, which is a passion of mine and an area that I am exploring in my scholarship. So what is restorative justice? So there isn't actually one single universal definition of restorative justice, spoken like a true academic, right? But it is a mechanism that is animated by a particular set of values and principles that lead to a response to the criminal, a means of responding to crime. And that is different from what we're familiar with the traditional criminal legal system in a variety of ways. And I think it's useful to think of it in a comparative way because it's a good reference point that I think people are quite familiar with, even though it's been contested in the scholarship and there have been a lot of arguments made that we shouldn't look at these two concepts, traditional criminal legal system and restorative justice as polar opposites. There are important differences, and I think it's helpful to highlight them in order to gain a deeper understanding of restorative justice. So thinking about the core questions that drive the response to crime within the traditional legal system, we're asking what laws were broken, what criminal laws were broken, who broke them, and what punishment do they deserve? Whereas in restorative justice, the core questions are who has been harmed, what are their needs, who has the obligation to address these needs and repair the harm. So unlike the retributively oriented criminal legal system, which imposes punishment on the offending party, punishment that's intended to be painful and unpleasant, restorative justice seeks to respond to crime through acknowledging the harm that was caused, the harm done to both victim and other people, other stakeholders in the community, addressing the causes of this harm and encouraging the person who actually caused the harm to take responsibility for it. So another point of contrast is that the traditional criminal legal system is an adversarial process pitting the defendant and the state against each other, where the victim is not actually a party. And so there's been a lot written about the state's appropriation of conflicts and harm done to victims, since victims aren't a party in criminal cases, whereas restorative justice seeks to empower victims and survivors by giving them a very active role in the process of determining how the harm that they experienced can be healed and repaired. So those are some key differences. And so scholars and practitioners have distilled key principles and values that underscore restorative justice responses to crime. And I also want to note that a couple of things. One, that restorative justice can actually be used to address harm that isn't a crime, that doesn't constitute a crime. It is and currently and has been used to address harmful behavior in schools, within families. So it doesn't necessarily have to be used concerning a violation of a criminal law, but this is really the context that I'm focusing on today. Also in a continuation, a cohesiveness of our panel building on the helpful information that Cynthia gave us. So another point is that restorative justice is actually not a new concept. It's been practiced by various cultural and ethnic groups for thousands of years, such as indigenous communities that have long used peacemaking circles to address conflict. But within the US and other Western countries, we see a modern restorative justice movement that started in around the 1970s, so not long before the founding of our Center for the Study of Dispute Resolution here that we're celebrating today. And so one of the fathers of the modern restorative justice unit modern restorative justice movement is Howard Zehr, and he helpfully set out certain pillars and principles of restorative justice that I'm going to share with you now. 3 pillars: focusing on harm results in obligations, and promoting engagement and participation. So the focus on harm requires understanding the harm that the crime has inflicted on the victim, on others in the neighborhood, in the community, on the victim's family, understanding what actually causes harm, and not limited to individual causes, but also structural causes that drive crime and that lead to people causing harm to others. And also restorative justice requires us, and at least gives us the space to appreciate the harm that the offender might have experienced themselves, perhaps earlier in their lives, that led them on a path to cause harm to others. And so even the language employed within restorative justice reflects this focus on harm. So typically, instead of offender or perpetrator, that individual is referred to as the person who caused harm. And instead of victim, it's the language of person who was harmed is employed. So that helps to center the focus on harm and understanding that harm and repairing that harm within restorative justice. So the second pillar is harms resulting in obligations. And these obligations are to understand and repair the harm. And so we're not only talking about understanding and an obligation from the person who caused the harm, that individual, which of course is part of it, but also there might be community or societal obligations to repair harm if there were structural causes rooted in society, such as a lack of support, a lack of job opportunities, poverty, things like that, that contributed to the harm being caused. And so restorative justice at its heart promotes engagement and participation. So whereas the traditional criminal legal system often sidelines victims, and empirical research has shown that there's very low satisfaction rates among victims whose cases have been who've had contact with the criminal legal system. And even when cases have been prosecuted and a conviction has been reached, victims have often felt very disempowered. In contrast, restorative justice seeks to give victims a very active role, but also have participation and engagement among all stakeholders who were impacted by the crime, including representatives from the community, and to have people come together and think in a collaborative way about how to address this harm, how to heal and move on and repair the harm. It fosters communication, whereas in the criminal legal system, a defendant is disincentivized from admitting to anything and is incentivized to denying having caused harm, committed the crime, is incentivized to minimize the harm. Whereas here within restorative justice, the person who caused harm is incentivized to reflect on that, to explain it, and to try to understand it. And it's seen as a non-punitive process. So another value is repairing relationships. And also thinking part of that is not only repairing the relationships between the person who caused harm and the person who was harmed, but also the person who caused harm, repairing their relationships with the community. Instead of looking to just exclude them and banish them and shame them, there's a goal of figuring how to effectively reintegrate that person into the community. Because also, if you think about structural factors that drive crime, and structural factors that protect against crime, one of the protective factors is having like a high level of community cohesiveness and collective efficacy, where people are very engaged in the community and they feel like valued members of the community rather than excluded and banished. So these are some of the core fundamental values and principles that underlie restorative justice. So on the ground though, what is this? We're still at the abstract stage. What does this actually look like? So common forms of restorative justice: victim offender mediation, peacemaking circles, group conferencing are common forms. There's a lot of overlap between these. So just to explain a little bit about this, what this actually looks like is the coming together of the person who caused harm and the person who was harmed in the presence of a restorative justice facilitator. And there's typically the involvement of other people, support people for both the person who caused harm and the person who was harmed, community members, people who are from the community, who are engaged and interested in having the community be a safer and more cohesive place. And this isn't just some one-off, sit in a circle, sing kumbaya, and then we move on. Restorative justice actually is a lot of work. And before the parties come together, before the person who was harmed and the person who caused harm come together, there's the restorative justice facilitator works individually to prepare for an extended period of time. And restorative justice sessions typically happen over an extended period of time because this takes a lot of work. And one of the goals being that as a group, one of the values of restorative justice is to eliminate hierarchies. So things like circles are very common, where people sit in circle so that there's not one person at the head who's driving the process, but everyone has a stake in the process. So I think I have only a few minutes left, so but I'm also happy to talk after the panel if people would like more details about how this works in practice. So some recognized advantages of restorative justice over the conventional criminal legal system, promoting victim autonomy and control, and victims can also identify things that would help them heal from the harm that a judge could not do in sentencing, for example. So it allows for more creative solutions that are more tailored to the particular individuals involved in the harmful event. It promotes healing, repair, understanding, rehabilitation, and also reintegration. Specific deterrence, because understanding is such a core part of restorative justice, to seek to understand what led this particular individual to cause harm to someone else, and to come up with a solution that will effectively ameliorate these root causes. Also, in light of our problems with mass incarceration, this is a way to avoid punitive outcomes, a way to avoid contributing to the problem of mass incarceration. And the person who caused harm within restorative justice, their humanity is recognized within the process. They're active in the process. And the goal is to repair and reintegrate them into the community. It nurtures our positive characteristics, such as working together to rehabilitate, understand each other, come up with a creative solution that will leave all of the parties better off in the best dispute resolution sense, as opposed to more the retributive instincts and the vengeful instincts that are often inflamed through the traditional criminal legal process. And existing research is promising, and I'm going to put a pin in that for 1 second, but and I'll come back to that. There has been a lot of resistance to restorative justice among a lot of people, not just prosecutors, but prosecutors are, arguably the most powerful actors within the criminal legal system. And so their resistance, I think, just merits particular consideration and has been engaged with in the scholarship. So some of the reasons, and I'll just put these all up here for an overview, and because of cognizant of time, I'm going to just highlight a few of them. So there's this idea that somehow restorative justice, a belief that it's not going to accomplish the public shaming that will effectively give the person who caused harm, what they deserve. So this very retributive idea, and it's not going to denounce what they did in public, because restorative justice happens in private. I mean, there are community members involved, but these happen in private, intimate spaces where these really deep conversations can happen. Costs have been mentioned, the cost of developing high quality restorative justice programs, having partnerships with, restorative justice organizations. But I would counter this with, it costs a lot of money to prosecute people and incarcerate people. So with elected prosecutors, we also have fear of public pushback, in certain incentives within prosecutors' office that reward things like getting convictions in terms of promotions and the like, over diversion to restorative justice. So I want to, I should move on, even though there's a lot more to discuss here, but you might be wondering, what does the current research say? So I'm focusing on systematic reviews and meta-analyses, which look, rather than only at individual studies, systematic reviews and meta-analyses look at a body of research, a large number of studies that answer particular research questions, such as, is restorative justice effective? What is the impact of restorative justice? So, and meta-analysis goes beyond systematic reviews, in that it actually combines the data from a number of studies, so that there's a much larger amount of data in order to draw well-grounded conclusions, as long as the methodology of the studies are similar enough. And I just want to say, we should take this with a grain of salt, because the existing body of research, I've noticed there are some methodological weaknesses, but these are the initial indications that restorative justice is associated with a modest but statistically significant reduction in recidivism as compared with the traditional criminal legal process. So there were studies that were drawn upon in systematic reviews and meta-analyses that compared the results from restorative justice as compared with people who went through ordinary prosecution, conviction, sentencing. And the second main finding, restorative justice is associated with increased victim satisfaction, more positive perceptions of procedural justice among victims, which isn't surprising because they're left out of the, largely left out of the traditional criminal legal process, decreased negative emotions among victims following restorative justice participation as compared with the conventional criminal legal process. So my last slide, and I apologize for taking another minute, where do we go from here? So in response to the prompt that was given to inspire this panel, I would agree with my fellow panelists that there is still a huge need and opportunity for meaningful contributions to the dispute resolution field. And in restorative justice, here are some outstanding questions. We really need more methodologically rigorous empirical research that examine the impact of restorative justice and ideally methodologies like randomized controlled trials with comparison groups that are allowed for causal inferences to be drawn. We need to expand the evidence base for identification of best practices because, as we know, restorative justice can look differently in different contexts. How do we overcome resistance among prosecutors and others to resistance to using RJ, and particularly in response to people who aren't juveniles, and also willingness to use it for in response to more serious crimes of violence or sex-based crimes? We should be comparing different restorative justice program designs to inform our understanding of what might be particularly appropriate for a certain situation and also best practices. And lastly, we need to compare the dynamics and impact of restorative justice across different communities and populations to see if there are different dynamics and different levels of receptiveness or particular approaches that might be more effective among certain populations and communities. So I'll leave it at that. Thank you.
Well, I can imagine the different commentators out in the audience who are like, I've heard 3 people talk about this. I'm getting it a little bit, but I'm not quite there. I am still feeling that all fruitful scholarship and dispute resolution has reached its peak. Now, Jennifer Robinall, can you push us over the edge so we don't buy that anymore?
I can.
Take it home for us. No, sorry.
I will try. Okay, but before I do, I wanna echo several of you who have commented on how good it is to be back here. And to thank Ilion for pulling us all together and Donna and Eric for your contributions. And to say personally how good it is for me to be back here and to see old friends and mentors and think about the benefit I got from starting my academic career here. I benefited from the insights of too many people to name in this context, but it's just, I'm grateful for that time and I'm really glad to be back here at Mizzou. Okay, so we've been asked to think about what's been done and whether and if there is anything left to be done. And I'm supposed to talk about psychology and dispute resolution, and there's certainly a lot that has been done at the intersection of psychology and dispute resolution. There's a long history of thinking about the interconnections between dispute resolution and psychology, and even think of core concepts that we talk about a lot. Procedural justice, for example, right, has permeated how we think about dispute resolution. Psychologists have contributed data and theorizing about things like fixed pie bias and impasse aversion and reactive devaluation. Lots of the things we talk about and lots of the things that we teach have come out of
psychological research into conflict resolution. Research has drawn on the psychology of heuristics and biases, and so Chris's work on settlement made great contributions in thinking about things like framing and options and anchoring and regret, right? All of those things coming from work on psychology. Len's work on mindfulness is grounded in work coming out of psychological science and neuroscience, and contributing to how we think about and what the effects of mindfulness awareness are. Some of you know I work closely with Gene Sternlight, another collaboration that came out of time at Mizzou. And as we worked on our book on psychology for lawyers, it just kept becoming a bigger and bigger book because there's just so much existing research on psychology and dispute resolution and lawyering, and thinking about all the ways that psychology is important to thinking about what we do as lawyers. So, we might ask whether all the good work has been done already, and you will not be surprised to know that I don't think it has. And so what I'd like to do is try to outline, I tried to sort of think of some umbrellas and some buckets that I could put some ideas in for where I think there is particularly work to be done still at the intersection of psychology and dispute resolution. So my first bucket is in thinking about lay understandings and lay experiences with dispute resolution processes. And importantly, thinking beyond sort of satisfaction with processes, but to think about sort of more psychologically rich descriptions of what people know about dispute resolution, expect from dispute resolution, how they experience dispute resolution, and so on. And so I've tried to just put a sampling of some recent work up on the slide. But we need to know, I think, more about what people know coming in about dispute resolution and dispute resolution processes, because in thinking about how to advise them and how to structure processes, it would be helpful for us to know what they know and what they need to be told and what needs to be explained, and what their expectations are. A couple of things that I've put up here are recent work by Kristen Blankley and Ashley Roshubra, a sort of law and psychology collaboration, thinking about what lay people do and don't understand about mediation and arbitration. I think Andrea this morning mentioned Gilad Bakar's work on what people think about NDRs. Sort of what's the lay perspective on their pros and cons and when we should have them and when we shouldn't, right? Donna has contributed a lot to this literature in thinking about litigant awareness of what processes are available in the courts that they are participating in, and thinking about what litigant expectations are of processes. I've been doing recent work with my collaborators, Jesse Bregant and Verity Winship, on what people think it means when cases get settled in the civil system. So read a news article about a case settling. Do people even know what that means? Sort of, but they have some misconceptions about what that means that I think has implications for, whatever role they may play in future dispute processes, if they come to those processes with a schema for settlement that doesn't match what we in law think a settlement is. So I think we've got a lot more to learn there about understandings and expectations that people are coming to these processes with. And then beyond that, we might also be asking how those understandings and expectations and schemas are developed. Right? Where are they coming from? Again, Donna's done some interesting work thinking about the role of attorneys and what attorneys' advice means to clients, what kind of influence they have on clients. Chris has done work thinking about the influence of attorneys. I was really excited to hear Sarah mention this morning that she's going to look at how arbitration is portrayed in the media, because I think thinking about how some of these processes are portrayed in the media can be really important. And I think there are a lot of open questions about how those portrayals contribute to what people coming into these processes think about them and expect from them, as well as other influences, friends and neighbors and so on. And then how those understandings and expectations affect people's decision-making, how it affects their likelihood to make claims, how it affects their decisions, whether that's choice of process, decisions to settle cases, to take a plea, and so on, and how those expectations affect their experiences when they're in the dispute resolution processes that they are in. And to pick up on a theme from my co-panelists here, thinking about what those understandings and expectations mean for dispute systems design, right? Thinking about what people are coming to these processes knowing can tell us about where the gaps are, what advice needs to be given, ways that programs can address those gaps, and thinking about how we might design variants of processes that are likely to lead to satisfaction and address expectations and create legitimacy of process. So I think that is my first sort of collection of things where I think there are a lot of unanswered but really important psychological questions going forward. Second bucket, lots of people have already talked about technology today. I think that's a big area in which there's lots of psychology and dispute resolution work to be done. Going forward, I think the sort of human computer and human online and technological interface is going to only become increasingly important. Even thinking about what technology to use, whether that's what technology to use in a particular dispute, or whether that's what technology a court should choose when they're thinking about their online dispute resolution program, really ought to take into account what we know and what hopefully we will continue to know more about the psychology of how people interact with those online and technological kinds of processes. So we should be thinking about and informed by how people are affected when they communicate through different kinds of channels. So people have access to different kinds of information when they communicate by audio or by video or through text, different ways of providing and different ways of receiving information in ways that have pretty complicated effects, and we need to really be thinking about those effects when we're choosing or designing our processes. Thinking about the ways in which synchronous communication is different from asynchronous communication, and for both better and worse, how those differences map onto the needs that people have when they're engaging in the kinds of dispute processes that we think about. So thinking about, I harken back to this morning, people talked about the multi-door courthouse. I think we need to have that same concept for thinking about technology, sort of whether we're going to use particular technologies, when we're going to use them, and how we're going to use them should be grounded in the psychology, as should our thinking about how those kinds of technologies affect our ability to provide access to justice and procedural justice and so on. And I think we've only started to think about and grapple with what AI is going to mean for dispute resolution, what AI is going to mean for the psychology of dispute resolution, for things like trust, for things like legitimacy, for things like bias, for transparency, for procedural justice. As AI develops and is incorporated into dispute resolution processes, we're going to need a lot of research to think about how human beings are understanding those technologies in this context. And there's been some research on technology and psychology and even in dispute resolution context, but a lot of it is old, at least old in tech time, and maybe in the field of dispute resolution time. A lot of the research is done in the late 1980s and early 1990s, and we know that we've come a long way in terms of technology since then, come a long way in terms of dispute resolution since then. And so even the findings that came out of those studies, I don't know how applicable they are to a world in which they aren't emerging technologies, but they are becoming more standard technologies. So lots of work to do on the tech front. Also, I think there's work to be done on a range of additional alternatives. And so this morning, the label for the session was talking about the traditional, non-traditional methods of dispute resolution. I think we need to think even more about the non-traditional modes of dispute resolution. So, Cynthia's work on plea bargaining and dispute resolution in the criminal system, and Rachel's work on restorative justice. Those are areas in which psychologists have not done as much work. They've only recently come to studying plea bargaining, but now they have discovered that there's work to be done there, and that work is really starting to grow. I agree completely with Rachel's assessment of the restorative justice empirical research, that there's some there. Not all of it is as rigorous as it could be, and there are a lot of questions still to be answered with really good research. I put up on the slide transitional justice, that I noted that the most recent best paper in the AALS section of dispute resolution was a paper on transitional justice. So I think there's a lot of work. Again, it's a place where psychologists, particularly political psychologists, have started to do some work, but there's a lot more we could be doing to be thinking about transitional justice. In my world of tort law, I would note that more and more cases are being resolved in bankruptcy courts. And while I'm not, those of you who know Bob Wallace will understand when I say I'm not willing to concede the ground of tort law to bankruptcy court, I am willing to acknowledge that a lot of it is happening. So lots of these cases are now being handled in bankruptcy court, and we need to think about what bankruptcy court is going to look like if it's going to be the place where a lot of these cases and disputes are getting resolved, and what that means for procedural justice and group dynamics and negotiation tactics in these disparate kinds of contexts. And then the last thing that I will talk about is that I think there's lots more room for psychologists to do work on the interplay and interconnections among the different goals that parties may have, or that systems may have, the different dispute resolution processes that are available, the different kinds of remedies, because I think processes and remedies and interests are all interacting with each other in ways that we haven't fully explored. And so thinking about those interactions, thinking about the ways that different psychological phenomena interact with each other. We've done a really good job of sort of cataloging a whole bunch of individual phenomena, but not as much work thinking about how they interact with each other in more complicated ways, what the boundaries of those effects are, what the mechanisms are by which they are occurring. There's a lot more work to do on that. Sarah this morning talked about the push and the pull, and you give some and you take some. I think that's true when we're thinking about the psychology of dispute resolution. We have to think about how these mechanisms work together, when they are useful and when they're not useful. When I taught the LLM students here at Missouri, I always wanted them to think about, sort of not whether something was effective, but whether it's effective and under what circumstances is it effective. And a lot of the work I think needs to go to that. Discussions this morning about self-determination and joint sessions and caucusing. We have a lot to learn about how people are experiencing those kinds of processes. Even things that we think of as being sort of core fundamental things we understand, like voice in process. There's some psychological research suggesting that it's not always so straightforward, that Donna has noted research where expectations might influence whether or not people want to have a voice and how they experience the voice that they are allowed to have. So I think I will leave it there. We could probably go on a really long time sort of articulating where there are really important questions that we still have to understand, but I think we want to spend a lot of time thinking about other questions and taking your questions.
Okay. We are convinced, right? We're at four, at least all but convinced. So just a couple quick questions for the panel. The first one, I'm gonna direct it to Donna, but anybody please feel free to chime in. So there was a lot of, in the past, the research has been comparing dispute resolution and alternative methods to trials, the litigation process. Are we done with that? Are we still comparing, or okay, we're done with that. Now we can just look at these processes and go.
I don't know about you, but every once in a while, I find that we in our field still are in a position that we're asked to defend ourselves. Like, why is mediation better for my client than, you know, what the court can do for them through adjudication in its own form? So I think that in terms of still convincing people, that kind of research is still valuable. I don't know why people still, you know, ask those questions, but they do. But I think though, you know, that's still the minority of people though, I would say. So for the majority, I think now we can focus more on best practices for how to be good advocates for people within the different procedures, because those are questions that I find a lot of people get asked at conferences, like, how can I do the best job for my client in this particular negotiation where the client is with me, you know what I mean, and the other side's there with their client. How can I do the best job advocating for my client in a mediation? And there's a lot more work that we could do. And, you know, I think our field is very interested in empirical research, more than a lot of other sub areas of law, where we are really focused on trying to understand what is the best approach to, you know, to handle certain things. And I think now we can relax a little bit and focus more on that, but I still think we have to keep the other stuff up.
All right, thank you, Donna. Anybody else on this? Okay, I usually count to 5 Mississippis. So I'm gonna direct this one to Cynthia. So Cynthia, you've heard a lot about self-determination over the years. We've talked about it a lot today. But I mean, let's face it, there are some people, especially in a criminal context, we're talking about mental health issues. Can they really be self-determinative? You know, there are people who are damaged from trauma, et cetera, et cetera. I mean, is self-determination just a construct for civil cases where everybody is mentally healthy, or is it different?
I think there's differences when we're looking at the criminal legal system because of the populations that get pulled into the criminal legal system. It's different than, say, you know, your average corporate, you know, situation, right? Your average corporate client. And thinking about how to protect self-determination is different in a context where the vast majority of people who are criminal defendants have cognitive disabilities, have substance abuse problems, have mental illness, right? And of course, when we start talking about trauma, that, you know, pulls in almost the rest of everyone, right? So, I mean, you know, this is a challenge, right? There's a challenging reality, and it's I think one thing that's important to recognize is about 80% of cases in the criminal legal system are misdemeanors. So for the most part, we're not talking about very serious cases, right? And so I do think, and there's been increasing work looking at misdemeanors and highlighting the importance of it, and the importance of not overlooking how we process misdemeanor cases. And I think that this is a piece of it, right? If we're looking at people where we're using the criminal legal system to manage something that really has nothing to do with crime and has more to do with illness, then we need to rethink that, right? And misdemeanors are an easier place to start with that rethinking, right? Because for the most part, there's some misdemeanors that are violent crimes, but for the most part, we're not talking about that, right? And so it's easier to talk about rethinking. But I think there's no question that it's much more challenging criminal legal system when you're talking about in the context of the plea negotiation, does the defendant knowingly waive his rights? And there isn't a whole lot of attention given in courts in your standard plea colloquy to did they really understand? Right? There's a lot of questions getting asked where the answer is yes or no, not explain to me what you just did here. Right? And if criminal defendants were actually asked to explain what's happening, we'd realize how little they're understanding. Right? And this is a real challenge, I think, in the criminal legal system. And it also presents the challenge of why are we rushing so much on so many of these cases, right? When we look at things like hard bargaining tactics that are routine, we don't know how often because of data issues, but we know it's routine. People are being pressured to make decisions immediately when they may have serious disabilities that prevent quick decision making that's really making thoughtful decisions, right? And so I think we do need to think about that, and that's where maybe dispute system design comes in, right? How do we think about doing better, recognizing what we're asking people to do in the criminal legal system, where are they starting? And how do we do a system if we're thinking about self-determination? Are we really accomplishing that if we're rushing through 120 misdemeanor arraignments in a court in a day? And I've seen that. large volume courts, right? It can be insane how many cases go through in any given day. How much time do people actually spend thinking about it? Or is it really self-determination when they're pleading out? There's serious questions that are not getting answered, I think, adequately.
All right, so anybody else? Yeah, go for it.
I agree with everything that Cynthia just said.
Okay, that's the way to do it. So what I also heard Cynthia say, and Rachel, I think that you probably agree, is that we are afraid of those answers. I think we are afraid of it, from systemically, we're afraid whether or not people understand what they're doing. Especially in the criminal context, because then we gotta stop and begin again, and I'm gonna call it the meatpacking plant, the assembly line form of justice stops. And it's kind of like those commercials where the person tries to pay with cash instead of their credit card and everybody gets upset. All right, so now I'm gonna ask you, Rachel, this question. You talked about like the private, public sort of portion of restorative justice. And I'm wondering how you said, hey, we gotta get more robust research and things along those lines. I'm wondering how that public-private dichotomy breaks down and impacts the future researchers who want to do this kind of work.
Thanks for that question. This is a really complicated question because with restorative justice, you're also, just in terms of getting access as a researcher is incredibly challenging. There are a lot of gatekeepers in the system and people are really nervous about it. This is why you often predominantly see restorative justice mechanisms, if they are used, they're used when you have minor crimes or with juveniles, where I think there's a lot more consensus about whether people can be rehabilitated. And so there are also, concerns about restorative justice principles actually being adhered to if the process is co-opted and enmeshed within the criminal legal system. There have been a lot of concerns about things that were really diluted and don't adhere to these core values and principles of restorative justice still being referred to in the language of restorative justice, or with aspects that, when incorporated within like the public criminal system, all of a sudden, there are some programs where restorative justice circles are allowed to be done, but a judge afterwards has to approve of whatever resolution comes out of that. Well, that undermines the principle of empowering the people who are actually involved in the process. I mean, the judge approving it afterwards, and this is just one example, is where programs where the judge is not even involved in the process at all, and just like as a post hoc has to approve whatever resolution comes out of it. There are also, so there are restorative justice organizations that refuse to collaborate or take any sort of referrals from prosecutors, from law enforcement, and because restorative justice, another value of restorative justice is that the participation be voluntary. But then if it becomes enmeshed in our public systems, and then even if prosecutors are willing to use their discretion to divert certain defendants to restorative justice, you have the question about whether it's voluntary, because what's the alternative? Is there this, these potential charges hanging over that person's head if they don't go through the system and don't say the right things? So there are a lot of, I think, legitimate concerns about the public-private spheres and where restorative justice initiatives are operating.
Yes, quickly.
Well, if I could just interact on this restorative justice and
Sure.
and the mediation piece on criminal stuff. I'm from the same circuit as Judge Shestowsky. Matter of fact, here her and I were colleagues. And I've been involved in some criminal mediations, and it seems to me where they really work. Oftentimes, what's my experience is not the cafeteria style, get rid of cases. I don't think that's where it's good. But in more serious cases where there is a remedy, there is a solution to be found, okay? There's a victim that's gonna be reasonable, there's a prosecutor that's not crazy, and there's a defense lawyer that has control of their client, and the client has some redeeming qualities. And then having a third person go in and say, we need to do this because from the family's point of view, it takes it, from the victim's point of view, it's over with, it's done. And from the defendant's point of view, is you're gonna get hit, but you're not gonna get buried, okay? And so maybe, just maybe, you have a chance to restructure what's gonna happen. Because instead of some mandatory minimum, you're gonna go do 7 or 8 years or whatever, you know? And in that situation, I think that kind of interacts with the restorative justice piece. Because oftentimes in this mediation process, the victims basically understand that the defendant's a person too. And they don't really want to see the defendant just get clobbered. And at the same token, the defendant becomes appreciative of the fact that the victims weren't totally out for blood in the situation, okay? And so this is a small number of cases. It's not like a lot of cases, but I've seen the dynamic I'm describing, I've seen happen fairly often. And I think it's sort of an intersection of the mediation piece and the restorative justice piece. So that's been our experience.
Thanks so much for sharing that. I think there's also an important distinction to be made between restorative justice and restorative practice. So it seems that the approach that you're describing draws upon and is inspired by restorative justice, but in terms of what and so those would be, taking elements and aspects of restorative justice is often described as restorative practice. A lot of the scholarship and around restorative justice really frames it as a non-punitive mechanism where punishment through incarceration is not something that is seen as really part of the solution towards repairing the harm. But I think restorative practice would be an appropriate way to describe what you're discussing.
Go right ahead.
Yeah, it's not pure restorative justice by any stretch, because it's more of in the nature of a classic mediation applied in the criminal context. However, restorative justice type concepts and outcomes can be a side effect of it, but it is not the same. But certainly some of those concepts can be inspirational or nice side effects to what we're doing.
And I think it also really helpfully, signals more creative approaches
For sure.
that I think are important to explore, both within research and practice.
Yes, for sure.
But the issue here was, and you started off by saying, with a reasonable prosecutor, a reasonable victim, and a creative criminal defense lawyer, we can get those settled all the time. And you're absolutely right. There are a lot of restorative practices that are involved if you have a good prosecutor and a creative criminal defense lawyer, but also the victim who's willing to come to a resolution and is not looking for a pound of flesh.
But I would say if you have a talented mediator,
You can get.
you can get there, and you can provide that reasonable approach, or even if you don't resolve it in a traditional way, if you have helped a lawyer establish trust and a good relationship with a client or a victim, that is also a win.
It also results in the prosecutor getting the wisdom to say that the prosecutor doesn't have to follow, but if the victim's taking a position that is just off the chart unreasonable, it insists that the prosecutor was saying no to the victims.
Yeah, okay, John,
Short question.
last question,
There is a question.
well, not the last question, but yes, yes, sir.
I have a little script editor. Does restorative justice only apply if you're facing jail time. I think that there's a lot of crime in America, particularly corporate crime, where you could go to jail, and you listed some of them up on the screen. Okay, but they're not facing jail. But isn't it still restorative justice? And I'm talking about antitrust, I'm talking about some of the EEO, the DOL, where they should be prosecuted, maybe, except they end up not being prosecuted. And so taking them through mediation, if part of the resolution is to correct their action in the future, isn't that restorative in some respect? Or do you have to say either jail or we're gonna do something else?
Okay, so we have a hot panel up here in the back row.
So, yeah,
Restorative, I'm sorry.
yeah, so I think, you know, what's interesting about this conversation is, we're talking about some cases some of the time, why not most cases most of the time? Right, and the reason we don't talk about most cases most of the time and looking at other practices is because we have too many cases. So we aren't stepping back and saying, why do we have too many cases? And should there be a more thoughtful process in deciding what to bring into the criminal legal system to begin with? And should there be different underlying rules? So, I mean, Andrea this morning talked about, you know, what's the system and what's going on here? And so, you know, one of the ways in this conversation has been framed is if you don't have mandatory minimums, if you've got an ability to do something more creative, and that goes to what's the underlying law. Right, and so I do think what's important when we're talking about what's going on in our criminal legal system is to recognize that there is lots of opportunity for innovation and for the kind of programs that we've been hearing about, but there's lots of things that stand in the way. So one of the things that stands in the way is the underlying criminal law. Anytime we're baking in mandatory minimums, the criminal codes in every state in this country are structured to give prosecutors extraordinary power. They can choose whether to file the same offense as a misdemeanor or as a felony, and they can choose what enhancements to add, and some of those are mandatory time enhancements, like use of a gun, other things are mandatory time, and that constrains the ability of other players in the system to be more creative if the prosecutor doesn't want to be, right? And so I think when we're having these conversations, it's important to think about what's the big picture, where's there the ability to make meaningful change, and where do we need to look at the underlying systems and structures and not think that a single process is going to save us from these larger systemic problems, right?
All right, Jennifer Robbins, we were talking at lunch today about ethics a little bit. And so ethics is kind of mushy in that, are we talking about just general morality? Are we talking about the law? Are we talking about both? How do they mix? Is this a place where you can see some psychological research?
It is.
Okay, thank you.
Shocker. And I think we're talking about both. And what I find interesting is there's been a lot of work by psychologists in the last maybe decade and a half on thinking about how people make decisions regarding ethics. And a lot of it comes out of psychologists in business schools. And some of that work has made its way into professional responsibility classes and some into CLEs on ethics. But I think only at the margins so far. And most of it is, you know, we're sort of taking research that's been done in other contexts and sort of trying to apply it to the things that lawyers do. And so I think there's both room for sort of more of that translation, but also room to be doing more research on the kinds of ethical questions and ethical situations where lawyers are making decisions and on decision-making by lawyers. And so Art has done some of the only work looking at lawyers. There's a couple of studies looking at ethics, I think by maybe criminal defense lawyers and prosecutors, but from my read of the literature, they're few and far between. And so given how much relationship there is both between thinking about how those decisions get made, how it's often not a problem of bad apples, it's a problem of human psychology, how we work our way into making bad decisions.
that there ought to be more attention to that, in training law students and training lawyers, both to understand the psychology of those decisions, but also in thinking about how to practice making good decisions in, hot context, right? So if we predict what we're gonna do, we all think we will do the ethical thing. When we're put into those situations, we often don't. And the best way to do that is to think ahead about those situations and practice, with some pressure, how we're gonna respond. And so I think there's lots of room both for research, for translation, for education, to do, a different kind of ethics education in addition to the learning the rules kinds of education that we've traditionally done.
About just the formation, right? The formation of ethics and how they get applied.
Yeah, the formation, the practice, I think that there's no magic answer, but if you understand things like, bad ethical decisions often follow from really small little ethical steps that turn us into, all of a sudden we've crossed a line and we didn't realize we crossed it 6 or 8 steps ago, right? Understanding that will make it less likely that will happen, right? And there's all sorts of other examples like that. Yeah, like when you're tired, like there's studies of people making decisions when they're tired, right? Much more likely to make a bad unethical decision when you're tired. Knowing that, right, might help you choose to make some of those decisions in the morning, whenever you're the least tired, or have a good meal, et cetera.
Same thing with parenting decisions, do not make them when you're tired.
Tired and hungry.
Yeah, and hungry too, don't be a criminal defendant, right before lunch. I want to thank you all for being here, I want to thank you all for those questions, and great questions, great comments, that's the kind of stuff we really like to have. And staying here all the way through the afternoon, and those of you who are 3Ls, again, in April, you will receive an email from Paul Laderhoff that says, hey, there's this great negotiation behaviors survey. Please fill it out. Please do fill it out. Now with that, thanks everybody. Thanks to Len. Thanks to Chris.